Hello.
Sarika, please start.
Good afternoon, everyone. Welcome to this first webinar of ICI along with SAFA countries on the topic international insolvency best practices. I would invite CA Gyan Chandra Mishra ji, who is the chairman of this newly formed Insolvency and Valuation Standards Board, to welcome the participants.
So much thank you, Sarika madam, a highly respected, very distinguished President of the Institute of Chartered Accountants of India, C. Ranjit Agrawal ji. I can see virtually also Khaldia ji, MD Triple IPI, Rahul Madan ji. He is MD Triple IPI. I can witness the presence of various distinguished speakers, Asfaq Tola ji, Honorable Vice President SAFA, and of course various distinguished participants who have joined us virtually. Good afternoon to one and all. I'm really very honored to welcome you all on behalf of Insolvency and Valuation Standard Board of Institute of Chartered Accountants of India, Triple IPI, and SAFA in this first in itself unique webinar, the international best practices in insolvency. Hence, as the President sir has boarded in the flight and he has to travel, so without speaking anything more, I'll first request Honorable President of the Institute of Chartered Accountants of India, Ranjit Kumar Agrawal ji, to kindly share his words of wisdom to all of us. Thereafter, we will continue the program as decided as per M2M. So over to Ranjit Kumar Agrawal ji.
Thank you very much, Honorable Chairman of this Insolvency and Valuation Standard Board of ICI, Gyan Chandra Mishra ji, and the Vice Chairman Durgesh Kabra ji, very respected the Vice President of the SAFA, Asfaq Tola ji, Triple IPI Chairman, our very honorable member, other members of the profession. Thank you very much for joining. This is the first of its kind seminar where Triple IPI and Insolvency and Valuation Standard Board of ICI and SAFA had joined together just to debate and deliberate on the relevance, implication, and the importance of the insolvency practice in India, in SAFA countries, other parts of the world. And it's very imperative that the kind of insolvency practice has started in India in 2016, last 6 years. The kind of amendments, the kind of development took place in country like India. This is the started first time. And in the last 6 years, more than 7 lakh crore resolution plan took place. And I'm very happy that there are 4,400 insolvency professionals in India. And out of these 4,400 IP in India, 75% and more are chartered accountants. So the 7 lakh crore and above resolution plan are taking place. The maximum contribution is being done by the chartered accountant, and that is the very good sign that the resolution plan are being carried over the not only other professionals, but the more important, the chartered accountant. So I hope various other sessions are here. I'm in the flight. So I compliment the chairman and the vice chairman and the SAFA leadership, Asfaq Tola ji, and the Triple IPI leadership chairman and the Madan ji for coming together and having this kind of initiative, which will go a long way in deliberation, discussion. And if some issues comes out after the deliberation, the Ministry of Corporate Affairs is coming out with the IBC 2.0. So we can help them. We can give our suggestion of the various nativity of this insolvency law so that our suggestions can be.
Sir, you are mute. Ranjit sir, you are mute, sir.
So this suggestion of this deliberation can be given to the ministry, which are coming out with the IBC 2.0, and the ministry can also consider our various requests. So I compliment and wish this conference a grand success. And thank you very much, Asfaq Tola ji, for joining from Pakistan and being a part of this very good initiative of the ICI. I'm also giving the Vice President of ICI with me. So we also want to have a hello to entire delegates for this conference. Vice President ICA.
Good morning, Aldi. I can see Aldi. Very good morning, Jan Bhai. Very good morning, Madam Shruti Gupta, Madam Shabir, MD of IIP Madam Sarika, Ashok Tobaji. My best wishes and compliments to the great conference that is being held today under the chairmanship of Sri Gan Mishra. We did resolve in Singapore and they have been actually last Friday we were in Singapore. People were strongly talking about the initiatives taken by to put the practicing of insolvency and resolution of the highest level. So I give my compliments to all of you. Let's all work together to make IBC more confident and ensure that the reform truly complying with the IBM. The best speakers, we're on the flight of it. So take off. Thank you so much. Goodbye. Thank you.
Thank you, President Sir and Vice President Sir, for your igniting speech. And we surely assure you that we together, not only insolvency bodies, but SAPA and ICI, triple IPI, we will all work together for the betterment of the profession at large and also to inculcate the habit of the best practices as far as insolvency is concerned. Thank you, sir.
And I also thank Haldia ji for joining hand with the Insolvency Resolution Board.
Oh, it's our pleasure, sir.
And I also welcome Ibrahim Sabin for coming here in a very important seminar. Thank you very much, Ibrahim. Thank you.
Thank you, sir. Thank you, President sir and Vice President sir.
Thank you.
So friends, let's again restore the opening remark. So I welcome Ibrahim ji, of course, Tola sir, Vice Chairman of the committee, Durgesh sir, and of course all the respected participants. We have just listened to the leadership. India, though the law is toddler, but lot of activities have happened in India as far as insolvency code is concerned, and we are certainly expecting a lot to happen in IBC 2.2 in coming time. Friends, the global advantage with respect to the joining heads and to inculcate the habit of the various best practices of the insolvency, that initiation has started from today. I am very precisely telling and very humbly telling from today means when last SAPA meeting was held in Sri Lanka, so we had resolved there that we shall start one webinar on best global practices in SAPA countries, and we will try to adopt the best practices therefrom. Today, we have started this new era, and I congratulate and compliment the SAPA team, triple IPI, and of course the team Insolvency and Valuation Standard Board SAPA ICI. Friends, the time has come that not only the best practices with regard to the insolvency, but accounting and other ethical practices to be adopted in order to sustain the best of the practices for the professionals, not only in one country, but at least in the SAPA countries at first move. I am really overwhelmed to have such wonderful response. About 800 members across the SAPA countries have joined this program, and this is a really wonderful initiative being undertaken by the SAPA leadership and of course this ICI and triple IPI leadership. Friends, if we see the law in SAPA countries with respect to the insolvency is evolving. There are some of the countries where the law, though is old, but the practices are slow, or they have not been practiced in consonance to the practices of the developed nations. However, now since lot of reforms are happening in and around the world, we will certainly witness so many reforms in our countries also, and we as one unit having our common goal certainly take this pledge that we will try to make this other side of the business where the there is default in the loans, there are certain financial crisis, restructuring is needed. There we will certainly try to assist not to the business houses but to make the government feel that the accounting professionals who have come across for this cause of the insolvency profession, they are contributing to their nations at the best. I'll not take much time as our leaders from international bodies, from India are here. I'll request Sarika to kindly continue with the program. And once again, I congratulate and compliment to each of the leaders who have joined from different places to this program. I, on behalf of myself, Triple IPI and SAPA, welcome each and everyone once again. Thank you very much.
Thank you, sir. Sir, there is a slight change. Actually, Mr. Ashfaq Yusuf Tola, sir, Vice President of SAFA, he has to leave for some urgent meeting. So before Ibrahim, sir, I would request sir to kindly address and
Thank you very much, Sarika. Thank you, leadership of SAFA, IIIA, and Indian Institute of Chartered Accountants, the chairman of Mr. Ibrahim of SAFA Insolvency Committee, distinguished participant, very good afternoon. I think this is again a landmark in the history of SAFA that we are organizing a seminar or a webinar which is on a topic which is a burning question right now. Insolvency is basically an act in economic distress, and we know that the world is passing through a very rough area, and we are facing challenges basically because of economic distress in the world. We have seen so many insolvencies during the COVID period. It is quite distinctive from the bankruptcy, and hence we need a uniform code for the SAFA countries. This is SAFA leadership's initiative to have a common code and to advise all the government in the region to adopt that code. I know for sure that India is far ahead in the region as far as this insolvency matter and act is concerned. So I think let's not reinvent the whole wheel again, and let's just take the best out of it, just follow the best practices of the region, for the region, by the region. Obviously, we can take initiative, we can take lead from the rest of the world, especially from the European Commission, because they also want to firm up a joint code for the entire European Commission. I know in US and in the rest of the world, this is age-old insolvency acts. Now let's take the best practices and let Ibrahim, our young leader from SAFA, initiate this lead. I assure you on behalf of SAFA that we'll pursue these webinars and seminars and knowledge sharing very frequently. And I know for sure we are developing an LMS for the benefit of the region. We are also organizing a workshop, a detailed workshop on forensic audit and on QAB, quality assurance programs, for those, especially my daughters and sisters of the region, to pursue their career from home even. So with these words, I'm again congratulating Institute of Chartered Accountants of India, IIIA, and SAFA Committee on Insolvency for arranging this webinar and sharing a wealth of knowledge from the very expert, knowledgeable experts from the region. Thank you very much. Wish you all the best. I congratulate you.
thank you so much, sir. Now I would request Mr. Ibrahim Shabin, sir, Chairman of Committee on Insolvency at SAFA, to address the delegates.
Thank you. So first of all, good afternoon, all the SAFA leadership members, esteemed invitees, speakers, and all the participants joining from all around the world from SAFA countries. I am delighted to address you all on this first unique webinar, which is being conducted after forming the SAFA Committee on Insolvency. I would like to thank ICI Triple IPI for arranging this webinar and onboarding such esteemed, knowledgeable speakers for this webinar. One of the key objectives of our committee is knowledge dissemination and resource sharing among member countries to foster a collective and a supportive environment in the SAFA countries. So I believe such webinars, such information sharing would assist all the member countries to develop the insolvency profession. From the committee meetings which we had, what I gathered was the maturity level among the member countries are vast. Some countries are developing their insolvency practices. However, some countries such as India and other SAFA countries have developed and has been practicing insolvency practices for quite some time. So they do have a lot of knowledge which can be shared. So I believe this is how we can develop a supportive environment where all the SAFA member countries can foster together. So with that, I would like to thank again all the participants who have shown their interest in this and who are here to learn and develop our profession.
Thank you so much, sir, for your address. Now I would request for a special address by Dr. Ashok Haldia, sir, who is the chairperson of Indian Institute of Insolvency Professionals of ICI, which is the first IP of the country. Welcome to you, sir.
Thank you very much, and indeed a great pleasure welcoming the dignitaries from the SAFA and the delegates from all over the SAFA countries. For me, it's indeed a great pleasure personally to be on a SAFA platform after a few years. It reminds me of my days when I was Secretary and Secretary General of SAFA for more than 10 years, part of different committees of SAFA, and also study papers which were brought in by the SAFA, including the one on the corporate governance and how to simplify, make the company law business friendly. So that's a great. So this occasion reminisces me back to those years. I was also part of the reframing of the constitution of the SAFA and restructuring the SAFA so as to be more effective in delivering the objectives of the profession of accountancy. Extending that, being a part of the this webinar, which is on the Insolvency and Bankruptcy Code, India has taken a lead, and the insolvency professionals have been the pillars of the Insolvency and Bankruptcy Code. They provide an important link between the law and its implementation, and in turn are important to provide a feedback to the government as to how effective the law has been and in what way the law needs to be modified in order to meet its objectives in terms of resolution and in terms of maximizations of the revenues from the stress assets. And as I said, the insolvency professionals are pillars, and the profession was not existent in 2016 when the IBC came in. So the challenge for all of us was to develop this profession, build the capacity, create an ecosystem for the profession in terms of its code of conduct, in terms of its monitoring, in terms of grievance, in terms of disciplinary, in terms of standards, and in terms of the operational guidance in the manner they perform while translating the law into the actions. And from that perspective, the IIPI has taken a lead and has done a yeoman's work towards this end over the last 6 years. We have brought in more than 15 to 16 research papers, guidance notes, ethical standards, peer review mechanism, monitoring system, and so on and so forth. And that's why 75% of all the CIRP being undertaken in the countries are the members of the insolvency professions. And the topic of the day is very important in terms of the international, the perspective. As the cross-border is very important. The group insolvency is very important. Unless you take an international perspective, you'll not be able to resolve these stress assets in an effective manner. And therefore, the conference today is very important. I only assure the dignitaries from the SAFA as well as the delegates from the SAPA countries, that should they require any support in terms of strengthening the profession, strengthening the individual insolvency professionals, or in terms of the capacity. Now we are only a webinar away in terms of dissemination of the knowledge and the skill sets. The triple IPI is only a call away, telephone call away. So I will not take much of the time. Possibly I know during the course of the day or course of this webinar, there is a session on the ecosystem of the IBC, and I'm sure you would be able to get a full idea as to what way the IBC in India functions and what are the pillars for the effective functioning of the IBC. So with that, thank you once again, and I assure you all the cooperations that you need. And as you used to say in my SAFA days, that the members of these professions are only a call away, irrespective of which country they come from, which country of the SAFA they come from. So I assure you that as far as the insolvency and bankruptcy court is concerned, they are also only a call away. You can always call. With that, thank you very much.
Thank you so much, sir. Now I would request CA Durgesh Kumar Kabra, sir, who is the Vice Chairman of Insolvency and Valuation Standards Board. Welcome to you, sir.
Thank you, Sarika. It's indeed a pleasure to welcome all the members joined from the various countries, more specifically in absentia, the President of ICI, Ranjit Agarwal ji, Vice President Charanjot Singh Nanda ji, Mr. Asfaq, Mr. Ibrahim Shabir, the Chairman of the Triple IPI, Ashok Haldia ji, and the MD of the Triple IPI, Mr. Rahul Madan ji, as well as the Chairman of the committee, Gyan Chandra Mishra ji. It's indeed a pleasure for me and also Suman Batra ji, Ashish Makija ji. Good evening to one and all, and I extend my heartfelt thanks to each one of you for being part of this webinar, which is being organized by IBSB of ICI with SAFA and Triple IPI. This kind of webinar gives an opportunity to participate, to enrich all the stakeholders on the important aspect under international insolvency, best practices, and an opportunity to listen to deliberate and presentations made by the eminent faculty. As we all know that the Insolvency and Bankruptcy Code was enacted in 2016 in the country, and it is a major historic reform being brought in India, which has helped economy laying foundations for market-led and time-bound insolvency resolutions framework. With the enactment of the Insolvency and Bankruptcy Code 2016, India took a historic step towards establishing a strong, contemporary, and complex insolvency framework. We all know that the Insolvency and Bankruptcy Code has been introduced with the overall objectives of the promotions and promoting the entrepreneurship and balance the interests of all the stakeholders by consolidating and amending the firms and individuals in a time-bound manner. As insolvency has been the most debatable area because of its requirement in today's scenario, international aspect to it has been demanding and challenging aspect. The cross-border insolvency and the best practices into it, which is going to be deliberated as the main theme today. And I believe that the cross-border insolvency regulates the treatment of the financial distressed debtors where such debtors have assets or creditors in more than one country. Typically, cross-border insolvency is more concerned with the insolvency of companies that operates in more than one country rather than the bankruptcy of the individuals. The Insolvency and Bankruptcy Code 2016, as well as we all know, has built a strong ecosystem in the insolvency resolution spheres in the country. Today, we are witnessing the result of the implementation of the code. International insolvency, cross-border insolvency best practices need to be looked upon with the keenness, as in today's scenario, world is getting closer and closer, that requires to adopt best practices in this area for efficient and smooth running of the company. I hope that you would have gathered good, you all would be having the good knowledge today, while the two speakers will be deliberating on the subject, and I'm sure that all will get benefited. With this, I welcome you all once again, and I also thank all the dignitaries who participated in this inaugural portion and session of this webinar, which is on the best practices on the cross-border transactions. Thank you very much.
Thank you so much, sir. Now I would hand over session to CA Shruti Gupta to moderate and take it forward. Firstly, we will start with Mr. Rahul Madan, who is the Managing Director of Triple IPA. Yeah, over to you, Shruti.
Thank you so much, ma'am. And I thank all the speakers and dignitaries who are present here. So without any delay, I would like to welcome Rahul Madam, sir, for his address to the audience.
Yes, thank you. And I hope I'm audible, and I'll take few minutes only. The stage has been set extensively. My job today in next few minutes is to provide the audience, which are SAFA countries and also in India, and heads up of the IBC journey in India so far. So very quickly, and my co-speakers in the ensuing technical sessions will cover many matters in depth, including the philosophical, commercial, and legal angle to many of the best practices of the law in India as well as abroad. So I'll just take a second to share the screen so that we can just, Shruti ji, you can confirm that you can see the screen.
Yes, sir. The screen is visible. It's not in the PPT
Okay.
mode. So maybe you can.
I hope it is now.
Yes, sir.
Thank you. So the few minutes I'll take focusing and giving some overview of IBC's ecosystem and key pillars so that in the next technical sessions, the audience can relate to what has happened so far in India with respect to the best practices in the global perspective. With these insights, I'm sure it will be helpful. So quickly, let me quickly start with what IBC consists of so that we can relate well to it, which is like key pillars. So key stakeholders, as we can call it, or the pillars, as we can call it, which are the contributories to the processes as well as beneficiaries of this insolvency law processes. So 2016, when it started, all these have been identified, the key pillars. So I'll quickly highlight the roles and responsibilities. At the top, I'll start with adjudicating authority, which is the first port of call as far as the legal jurisprudence is concerned, the National Company Law Tribunal, NCLT in short, in India, post which the appellate authorities come in, the NCLAT, which is the appellate tribunal, followed by appeal lying in the Supreme Court, Honorable Supreme Court of India. So that is the legal, the infrastructure. Now coming to the regulator, the apex regulator of IBC or the insolvency law in India is called Insolvency and Bankruptcy Board of India, which regulate all the agencies as well as insolvency professionals in the marketplace. So quickly, the next tier of frontline regulator. So there are dual system of regulatory framework in India. Likewise, to some extent in UK also. The frontline regulator are called insolvency professional agencies, which we represent. Like I'm the head of or executive in charge of IPA, called Insolvency Professional Agency in the technical terms. And like us, there are two more. So in India, there are three. One is by Company Secretary of India and also by Cost and Works Accountants Body of India. So I'll cover that aspect a little later. Now coming to the next pillar is the commercial wisdom. Who holds the reins of the decision making in terms of applying the commercial mind and the wisdom. Committee of creditors, which is a amalgam of uh, those who have lent money to the corporate debtor in stress. So we will cover more such in the next technical sessions. I'm sure our co-speakers will cover more. The process driver, here the role of insolvency professionals come in, and not only individual insolvency professionals, but also the entities which are firms, either in the form of a company or a limited liability partnerships. And IPEs is a recent development. Earlier, individuals were only operating in Indian ecosystem. Very important, as already mentioned in the inaugural comments. So the majority of insolvency professionals in India are chartered accountants, roughly 55%. Rest consists of many other corporate or professional body like company secretaries, cost and management accountant, even managerial background or management professionals, advocates as well. Now, coming to one interesting experiment in the IBC ecosystem is the information utility, which is responsible for collecting and disseminating the information critical to the process. IU in short, in respect to defaults, proving defaults, providing necessary audit trails in respect of many such process-driven activities. The role of IU will increase in next years or next time to come. Now, the remaining stakeholders are the users or the beneficiary, like resolution applicant, which takes over the CD's management from the previous ownership. Operational creditors are primarily suppliers, even employees who are not the lender to the corporate debtor. And of course, the previous management and the employees, as I mentioned. So these are the broad pillars quickly. Just to give you a heads up on what has been done so far, last 7 years, it has been proven as an effective and expeditious mechanism to the creditors. As I already mentioned, 3 IPAs, 1 IU, roughly 4,500 IPs, 118 IPEs. Now also the valuers bodies and as well as valuers in the market are also there. So over 5,000 registered valuers are also operating within the IBC ecosystem. Very important role of theirs because of liquidation value and the fair value of the business in questions are to be carried out ongoing basis. Now till December 2013, so far little over 7,000 insolvency processes initiated. Resolution has happened, roughly 900 cases. Liquidation, which is the residual action, not really the preferred action, roughly little over 2,000 cases. Similarly, little over 2,000 cases closed or withdrawn because of certain settlement happening in the course of processes, and roughly 1,900 CRPs are ongoing as we speak. So with this inside arena of IBC, let's talk about how many cases are not yet admitted and still have been influencing the actions of the market. Roughly over 20,000 cases, and this could be a little over maybe 25,000 also, cases withdrawn or settled even before admission. That means there is a behavioral change which has been triggered thanks to the deterrent effect of the insolvency law, because the management or the ownership is always possible to be taken away from the previous ownership to the new management. So hence the behavioral change. So in terms of the recovery percentages, 32% overall has been so far recovered in terms of the claim size, claims proportion. If this recovery is applied to the liquidation value, this percentage of recovery will look like 168% of the liquidation value, which is certainly better than previous regimes. Industry-wise breakup is also available. Roughly 38% of the overall cases under IBC are manufacturing industry-driven. Rest majority of the cases are either real estate, construction, and retail, and some others. But timeline has been a concern. I'm sure the next session will talk about more delays, etc. But yes, delays are happening, but still it is better from the previous regimes. 550 odd days it takes to resolve, and liquidation it takes similarly around 486 days. But the cost of processes or cost of recovery process under IBC is significantly lower compared to the previous regime, which is roughly at 1%. Quickly in a minute, I'll take to highlight the frontline regulator as we represent in terms of managing or regulating the profession along with IBBI on the front line. So our role as an IPA, and likewise it happens in UK also, we are in a role of quasi-legislative or executive and the quasi-judicial. So how regulative and quasi-judicial roles are defined in the IBC, and beyond that, we also take pride in creating a great amount of capacity building initiatives and facilitating the capacity building of not only the professionals but also the stakeholders, which is one of the executive role. And of course, judicial or quasi-judicial functions revolve around taking disciplinary action against the erring members of ours. But that is something we will not really talk about much, because that is only a residual action. We will more and more focus on the capacity building so that such actions or misconduct related matters do not even come up for scrutiny. And of course, we are developing a lot of standards, best practices, which is our regulatory or the legislative functions. With that, in the last, I like to end by saying we also take pride in sharing that IIIPI's members constitute 63% in numbers, but 75% of the entire CRP of the liquidation action are being managed by IIIPI's member. Rest others are being managed by two other insolvency professional agencies. With that, thank you very much for the patient hearing. I'll take a break, and we look forward for the continued.
Rahul,
Yes.
it's Ashok Haldia. Just to add one point on the topic of the day on the cross-border insolvency and the group insolvency, the IIIPI has brought out research publications, guidance for the insolvency professionals. If any member of the SAFA region wants to have a copy of that is available on our site, or can write to us so that we can mail that out. Thank you.
Thank you, sir, for the clarification. Thank you, and over to you,
Thank you.
Shruti. Thank you.
Thank you so much, sir. Thank you for sharing the roles and contributions of IIPI with the audience. Now, without any delay, I would like to welcome the first speaker for today, Advocate Sumant Batraji. He is a globally renowned insolvency lawyer with an impressive 3-decade career specializing in insolvency, bankruptcy, and related laws. He is a senior international consultant to IMF, World Bank Group, and OECD, has worked extensively on policy matters in Africa, Eastern Europe, Middle East, and South Asia. His contributions to reform in Indian insolvency systems are well recognized. He has held leadership positions in prestigious multilateral, global, and national organizations. He is a regular contributor in Economic Times and other prestigious national dailies and magazines. He has served on editorial board of Insol International's publication, Insol World, for 4 years. He is a frequent speaker at various international and domestic conferences. His policies come from being on multiple expert committees and work groups constituted by the Government of India, and a stint as a senior consultant with various institutes. Sir, with your immense experience and knowledge, we are sure that we are going to learn a lot from you, and we are eager to learn from you. Over to you, sir.
Sir,
Thank you.
sorry, you can continue till 3:15, sir.
All right,
I've
so
given you, yeah.
thank you
Yes,
so
please.
much, Sarita, and thank you so much, Shruti, for a very generous introduction. Thank you, ISCA, IIP, and SAFA board for inviting me. It's always a pleasure to be able to share my little knowledge and experience of insolvency law. I also wanted to apologize. I know that my video was on while they were just trying to sort of, put my chair into order. It was troubling me a little bit, but it was inadvertent. The topic that is given to me is talked about the international aspect of the Indian insolvency law. in the context of global best practices. I don't want to talk only about the global best practices. I'd like to contextualize it with how, over the last more than 7 years, India has applied those best practices in the law or in practice, whether it is the policy making is concerned or the market standards are concerned. And I will touch upon 6 or 7 areas as headline items, if I may say. But let me start by emphasizing, as Rahul was mentioning before me, about the various contours of the insolvency law that was enacted in 2016. It was quite apparent that it has 2 very distinct features. One, that it borrows from the global best practices. The Bankruptcy Law Reforms Committee that was established to propose the new insolvency framework in India looked at 3 key documents at that point in time, which in some form or the other contain what one can say with a sense of authority are the global standards and guidance documents for policymakers around the world, which have been developed with an effort of about 8 to 10 years by the global fraternity. The first is the UNCITRAL Legislative Guide for Insolvency, which has been adopted by the General Assembly. India was a member of that as well. It's a very comprehensive document which contains, essentially, after huge discussions, the various options of the best insolvency framework and system a country can provide for itself. The second is the World Bank Principles for Creditor Rights and Insolvency Systems, which also have been developed by the World Bank in extensive consultation with experts around the world after studying various systems, which in a way sets down the principles, the key elements, the foundational principles for any robust insolvency system. And those are also compatible with the UNCITRAL Legislative Guide. And the third is the various best practices or jurisprudence that has developed in the last many years since the modernization of the insolvency law starting from the 1970s. So these were the 3 large areas that the Bankruptcy Law Reforms Committee looked at. At the same point in time, you heard Rahul mention about the information utilities and some of the other aspects, like, for example, even the regulator IBPI. Now, whether it is the regulator as an IBPI, Insolvency and Bankruptcy Board of India, or the information utilities, which are kind of repository of information provided by the lenders with regard to the debt and the debt defaults, are very distinct to India. The point I'm making is that not only have we followed international best practices, but we also have been creating, through our experimentation, indigenous best practices which could be followed in many other jurisdictions. For example, the Insolvency and Bankruptcy Board of India, which has been a great success as an experiment, is the first of its own kind of a regulator in the world, which not only regulates the profession of insolvency and the valuers, but is also responsible for providing the regulatory framework without in any manner having any role as that of a bankruptcy court or by being intrusive in the process on a day-to-day basis. Just provide a framework in order to complement the law, and also in a way, therefore, not having to go to the parliament time and again if there are things that can be addressed by subordinate legislation. So these 2 combinations of following the best practices and creating best practices, which are in some way best customized for the dynamics and the characteristics of a particular economy and country, together have created what I can claim without any hesitation a very, very robust and exemplary insolvency system. Not just this system, but also, as you heard from Rahul, the kind of professionals that have come forward and how it has become a full-fledged industry. We have also been able to create in the last 7-8 years a very dynamic insolvency industry where many stakeholders have found new opportunities, whether it's the valuers, the insolvency practitioners, whether it is the lawyers, or whether it is the secondary market for distressed assets, whether it is also multiple other players in the entire insolvency ecosystem. And in a way, therefore, the point that I'm trying to make is that that for us, it is the law itself and the entire ecosystem itself should really comprise of the best practices in order for us to follow the best practices, or in order for us to be able to create best practices as subsets of this law. I will now give about 4 to 5 examples of how India continues to not just follow best practices, but also create one by adopting leadership, thought leadership in various areas, by taking very experimental, indigenous, and steps that could be seen to be those that are being replicated and appreciated, applauded around the world. So these are about 4 to 5 examples that I will give in the limited time that we have. The first is, we heard a mention of the cross-border insolvency law by a few speakers before me. Now, cross-border insolvency law is actually something which draws its terms from the UNCITRAL model law and concept of cross-border insolvency law, which provides a kind of a framework which has also been adopted by the General Assembly, which deals with 3 situations where either the parallel insolvency of an enterprise or its group starts in different jurisdictions, geographical jurisdictions. 2, if there are creditors of an enterprise which is undergoing insolvency are located in more than one geographical location. Across the borders is what I meant. And 3rd, also where the assets of an enterprise in insolvency are located in different jurisdictions. So in these situations, the insolvency would be termed as cross-border insolvency. When in India, the Insolvency and Bankruptcy Code was being proposed by the Bankruptcy Law Reforms Committee, it suggested, and to some extent rightly so, that we need to first of all establish our domestic national insolvency law. And once we are confident that a foundation of a good, effective insolvency law is in place, we should then look at the cross-border insolvency law. But the Parliamentary Joint Standing Committee to which the draft bill was referred in 2016 did not agree with that. They said, no, if India's aspiration is to become one of the top 4-5 economic powers with 3rd, 4th, 5th largest economies, as was the ambition, aspiration at that time, we can't do that without adopting the cross-border insolvency law. So therefore, some amendments were made in the bill to introduce certain elements, but that was still not complete enough because we didn't really have the time, the luxury of time to examine that in detail and introduce the law itself. But 3 years down the line, the government asked this chairman of the same committee and myself to propose a draft of the cross-border insolvency law, which we did after going through 3 years of rigors of expert views insolvency law committee, which is the standing committee that we have in the country to review the developments and propose recommendations from time to time of laws and regulations. After going through public comments and also some committee which had applied its mind to it, we do have now a proposed cross-border insolvency law, which is waiting to be passed and hopefully would be in probably in about, if not later part of this year, early next year. Now, while all that has been happening, the Indian courts have been very, very proactive in ensuring that the absence of that law should not compromise and affect the efficiency of the insolvency cases that come to them, where a cross-border insolvency may be involved. And therefore, in a number of cases, both the courts and the practitioners have innovated, found ways to ensure that applying the principles of the ancestral model law, the efficiency of the process is enhanced and cross-border issues are addressed. And one of the examples, living example of that, which is being applauded again globally, which was also the first of its own kind in the world, was where when one of India's airlines, Jet Airways, a premier airlines, went into insolvency in Netherlands and also faced an insolvency in India, on the directions of the Indian court, both the insolvency professional in India and the liquidator appointed in the insolvency in Netherlands got together and signed a cross-border insolvency protocol where neither Netherlands and India has a law in place, but they adopted the principles of law by way of a contractual understanding, drew up an MOU, applying mirror images of the ancestral model law, and got that approved from the courts in both jurisdictions while retaining the sovereignty of both the courts, but at the same point of time, allowing both the professionals to work on those principles and ensure that the liquidation in Netherlands was resolved, all the lenders were paid, even an aircraft that was attached there and lying parked in Netherlands, Schiphol Airport, was allowed to be sold, and the distribution of the proceeds done in a manner where all the creditors in Netherlands were paid off, and then money was also released to India to be used to deal with the distribution here in accordance with the Indian law. So these are examples of how international best practices have been followed, even where the law correspondingly may not be in place. The second example I'd like to give, also similar to cross-border insolvency, is the group insolvency issue. Now, in group insolvency also, the ancestral model law on cross-border insolvency has developed in the last 4 or 5 years. We have a component of that which is called as group insolvency, especially those that are located in different geographical jurisdictions. So if a holding is an insolvency in US, then how does a subsidiary get treated in India, or the other way around, or associate companies or group companies or their assets. And there also, there are about 4 to 5 excellent examples where the Indian courts have allowed the consolidation of group enterprises in insolvency to take place, especially in the real estate sector, where the holding company holds the license to develop the real estate and is the ones which sells the products, but the various projects may be located in different parts of the country with different sitting in different enterprises, with land being held in them and even the development taking place there. They have allowed the procedural consolidation to take place, again drawing from the principles of the global best practices. And that has also worked very, very efficiently, though not free of complexities and challenges without the law being there. But again, in group insolvency, an expert committee was set up by the government of India, and that has submitted its report. Based on that, it is expected that as part of IBC2, as Gyan Mishraji was saying in the beginning, as IBC2, we will see those also seeing the light of day very soon. The third example that I wanted to give you also of the India looking at international best practices is how to use technology, in particular the artificial intelligence in insolvency or insolvency system, process, procedures. Although it is still at a very nascent stage, but there is a huge amount of investment, both in terms of thinking, in terms of resources, in terms of vision that have been put in that. And I'm very confident that the effort that has been done already is also something which puts us way ahead of many, many jurisdictions, including some of the advanced economies. We have always been way ahead as far as the technology is concerned. Right from 1990s, late 1990s, India has digitized a lot of its registry systems, both in terms of land registry, in terms of the corporate registries, Securities and Exchange Board of India system, the entire spectrum. And of course, more lately, the digitization in terms of the economy as a large in various areas, whether it's the modes of payments are concerned and everything. And also in terms of how we have moved to hearing virtual cases virtually, or even in a hybrid form. Now, all this produces together an ecosystem where in various components of the insolvency process, the technology is applied, whether it is gathering data, whether it is submitting data by the insolvency professionals, whether it is the collating of that data, whether it is the analysis of that data by ABPI. All these put together shows that how in the last 5 to 7 years, India has invested heavily in technology in the insolvency space in order to keep the entire insolvency ecosystem of global standards. So this was the third point that I wanted to make. The fourth point that I would like to make is on the bank insolvency. Again, this is a very important area for any economy in India, which is aspiring by 2027 or 2030 to become the third largest economy, displacing Japan at the moment, as we think. I feel that one of the key components of that economic growth will remain India's financial sector. And India's financial sector has, despite its non-performing assets, performed exceptionally well. Now, of course, the non-performing assets have come down to less than just about 3%, significantly by 300% in the last 7 years. And the various kinds of instruments and innovative lending, borrowing techniques that have come up, Indian financial sector is going to become a more and more contributor to the Indian GDP growth. And that being so the case, it is also important that we have a sound insolvency system in place for the Indian financial institutions. Keeping that in mind, the Government of India had introduced in 2017 a bill for the insolvency of financial institutions, insurance companies included. But in 2018, it had to be withdrawn because there was some dissatisfaction about certain aspects of the bill. But in the meantime, UNIDROIT, which is again a part of the United Nations infrastructure institutions, has constituted a working group. This was done after the Lehman Brothers crisis in 2008. But it has been working now on producing a global model, a standard document for small and medium enterprise bank insolvency. And Indian Reserve Bank of India is part of that working group. Incidentally, I also am an observer on the working group, sort of representing the private Indian market stakeholders. And we have been working on contributing the inputs, providing inputs at the UNIDROIT work from India. And we are quite hopeful that when UNIDROIT finishes its work, which is expected towards the middle of this year, India will very soon take up from there. And hopefully we will see next year the bank insolvency bill being brought before the parliament. In the meantime, while all this has been happening, the Insolvency and Bankruptcy Code was amended to include provisions for insolvency resolution of financial service providers. An amendment was made in the law to enable the central government to notify certain institutions which could be subject to insolvency resolution under the Insolvency and Bankruptcy Code itself, because the code originally applied only for corporate persons, which included the companies as well as the limited liability partnerships, and individuals, which includes, of course, individuals who are those who are guarantors to the corporate debtors or who have economic interests, for who run businesses as partnerships and proprietorships. But there were financial services providers were not part of this. But because one of the financial service providers in India, which is huge, was facing distress, the government took urgent steps to amend the Insolvency and Bankruptcy Code to enable that enterprise to be resolved through the insolvency process of the IBC. A special dispensation regime was created through regulations and some amendments in the law. And since then, three financial service providers, which are non-banking finance companies, have been pushed into insolvency by the Reserve Bank, because only Reserve Bank of India can file insolvency petition against the financial service providers. And as a result of that, this law, the IBC as we call it, has come to be used also for financial service providers, and very well. Although it still remains to be seen as to whether after the new bank insolvency law is introduced, whether this part will be transported there or will be retained here. But the fact remains, again, India's intervention in this area was very foresighted, full of foresightedness, was something which again showed international thinking, which showed also that even where there are no examples exists globally of bank insolvency being part of the insolvency law for the corporate persons, how we introduced there, took the risk, and it has worked very, very well. So that, I would say, is the fourth example. Now, the fifth example that I'd like to give is also in the area of research, because one of the most important aspects of developing policy is that it should be based on cutting edge research. It should be based on assessment of how the law has worked on ground and what you need to do in future, prepare for that. And all should be done not just by some set of people sitting on the expert committees or in the corridors of power, but based on excellent world-class research, which produces evidence on the basis of which the policy could be made on an informed basis. And I have to say that this is one of the remarkable approaches that we have taken in India. Again, the learnings come from US, UK, Singapore, how they, even Australia, how they invest tremendously, European Union included. All these advanced economies invest tremendously in research. And right from the day one itself, as IBC was being thought through, it was clear that there will be a total impact assessment from time to time. Researchers will be asked to research, and that will be encouraged. And the Indian bankruptcy regulator itself holds research conferences every year where papers are invited from the market. They also commission research on a standalone basis. They do a lot of research in-house. And Insolvency Law Academy, and of course ICAI, IPA, they do their own research, and some of it is excellent, and the kind of best practices documents they have produced is also phenomenal, which are of such great use to the market. One of the organizational think tanks and research centers that I had, Insolvency Law Academy, that also has been set up only for the purposes of doing research, essentially on insolvency, and produce a cadre of scholars on insolvency. And we have, in the last 2 years, ever since we have been set up, produced some world-class literature, which is being used not just in India, but abroad as well. So all this collectively also shows as to how, even in the policy making, policy assessment, in terms of reviewing the law, there is a heavy inclination and dependence on research-based evidence rather than just erratic, knee-jerk responses to policy making, which again is a very different kind of an international best practice and standard approach, because we tend to sort of see that only in practice but not in policy makings often. And there's again a learning which has come from the developed countries, and India has embraced it with open arms. The last two comments that I wanted to mention, one on another best practices, international best practices, is that, and then of course I have a concluding comment as well. The in terms of the best practices, again, in its research, in its deliberations, India has been looking at about 8 to 10 years ahead. The kind of thought leadership that exists at the moment, it just doesn't want to be reactionary anymore. And this comes from the fact that India is one of the top 4 economies in the world. India is something which is looking at playing a dominant role on the global center stage of economy. And that being so the case, India has to show leadership, mature leadership, in almost all aspects and thinking. And therefore, at some point in time, while of course learning from the experiences of the advanced economies, not lose sight of the fact that many countries in the world, in particular SAFA countries, the African countries, some of the Eastern European countries, are even some of the South American countries, are all quite similar in culture and approach. And therefore, not everything that is done in US, UK, European Union, or Australia or Singapore necessarily applies as well to India or may work as well to India. And therefore, there is a need to customize some of these best practices for the local country need. And that's where all these learnings from the 7, 8 years and the vision that we have can come in very, very useful for many other jurisdictions. And from that perspective, the thought leadership is totally look south approach and draw from the dynamics of these countries, including SAFA countries, in terms of their cultural approach, in terms of their social fabric and things like that, and see how these can be best put together in the local policy. And from that perspective, number of initiatives are being considered going forward for the overall insolvency ecosystem. The last point that I wanted to make was something which is concerning the SAFA itself. I know Mr. Haldia made a very, very enthusiastic pitch for the of offering to help in many manner, and I compliment him for that, because certainly ICAI and IIII PA, yeah, it can make a huge contribution there. I believe that their contribution from the day one has been very, very significant. And I would only like to, through Mr. Haldia and Rahul, offer that at Insolvency Law Academy, we will be also very, very happy to support. Insolvency Law Academy is already working with the World Bank and IMF in Sri Lanka in the insolvency reform there. And we are leading the capacity building initiative there. And we'll be quite delighted when the new law is passed, which is expected in about a couple of months, to invite IIPA to join hands with us in the next capacity building institution effort that we do there, because the World Bank has sort of asked us to help them there. Similarly, in Nepal, we have tied up with many institutions there. We are helping the capacity building of the academics. We are both the chartered accountants, academics, and the lawyers. And we'll be very delighted again I'll be happy to discuss with Rahul as to how we can do things together there. Similarly, in Bangladesh, also there are some discussions on, and Bhutan also recently reformed their law, which is based on the Australian law, though primarily because it was funded by Asian Development Bank. But we are also very inclined to support these SAFA countries, and we'll be very, very happy to join hands wherever you are taking the initiative as ICA or IIIP. And similarly, wherever we are taking the lead, we'll be very happy to invite you. And I'll stop here. And once again, thank you for this excellent initiative for these SAFA countries, because we have a lot in common and we can do a lot together, and also for inviting me to share my views. Thank you so much, and thank you, Sarita, for coordinating this. Over to you, Shruti.
Thank you so much, sir. Thank you so much, sir, for sharing the initiatives that are available and future prospects that are available with our audience. It was a great, insightful session. Thank you so much. So without any delay, I would like to welcome the second speaker for the day, Dr. Ashish Makhija ji. Dr. Ashish Makhija ji is a highly esteemed legal professional specializing in insolvency and corporate law. His extensive qualifications include being a fellow chartered accountant, an insolvency professional, a cost accountant, and a practicing advocate. With a wealth of experience and expertise, Sir serves as a managing attorney at AMC Law Firm located in New Delhi. Throughout his career, Dr. Makhija has been deeply involved in advising on numerous significant cases of corporate insolvency and liquidation. Notably, he held the esteemed position of standing counsel for the official liquidator attached to the High Court of Delhi for a tenure of 6 years, demonstrating his profound understanding of the legal intricacies in this domain. In addition to his practical experience, Sir is also an accomplished author and have penned several best-selling work on the Insolvency and Bankruptcy Code and corporate law. His contribution extends beyond the realm of legal practice, as he has served as faculty in various professional bodies and prestigious law colleges in India and internationally. Sir, with such vast experience and knowledge as yours, we are sure that you will share with us immense insights. Over to you, sir.
Thank you, Shruti. And I think this is a great opportunity for me to present, you see, the Indian perspective. And I think I must thank and I must appreciate the Institute of Chartered Accountants, the Insolvency and Valuation Standards Board. Now it has been formed as a board now, and of course of ICI, and of course IIIPI ICI, which is being led by Mr. Rahul Madan. I think these initiatives are truly encouraging, and I think the word must also spread that India is also establishing the best practices on its own. As my earlier speaker also mentioned, that we are not only following international practices, but we are at the forefront in establishing those practices. So friends, good afternoon to all the esteemed guests, distinguished experts, and my fellow colleagues and fraternity members. Well, it is indeed my distinct honor and privilege to address this international and domestic audience today on a topic of extreme significance in the global economic landscape, which is the Indian insolvency and bankruptcy law. Friends, as we navigate through the complexities of the insolvency frameworks across jurisdictions, I'm also delighted to shed light on India's progressive approach, emphasizing best practices that have been instrumental in shaping the country's insolvency landscape. I must share a small anecdote. I was doing my master's in law in international bankruptcy and insolvency from US. And at that particular time, that was way back in 2009-10, and I always wondered when India is going to have a similar law, which was prevalent in US for a number of years, that when we are going to have that law. Well, by the time I completed my doctorate, we have that law. So, friends, I think from one education to another education, India has also progressed as I also did my progress. So, friends, let us also understand. Let me start with understanding the Indian Insolvency and Bankruptcy Code. Let me give you a context and also understand the foundation. Of course, my previous speaker mentioned that it was primarily based on the Bankruptcy Reforms Committee report, which is a fantastic report. I must suggest that if anyone wants to understand the Insolvency and Bankruptcy Code, they must go through and read the Bankruptcy Law Reforms Committee report. Friends, I have read number of reports on the subjects of insolvency, subjects of corporate governance, corporate law, but this is one of the finest reports which I've ever read. It is, and there are few reasons which I can give you. Then the first reason is that it has been written in a very simple and a clear language. So if you want to read, you want to see what is the genesis of IBC, how it was framed, I think it makes a very good reading. Number two, there is a change of mindset. And I think most of us will be very happy to know that in the entire report, instead of using the word he, him or his, the committee has used the word she and her. So change of mindset, my dear friends. I think even for this reason, one should go and read this report. Well, Indian bankruptcy law, as we all know, that it was enacted in 2016 and it represents a transformative shift. I don't even call it as a paradigm shift. I call it as a transformative shift in India's insolvency landscape. It consolidates and also modernizes the existing insolvency law into a single comprehensive legislation, which what we call it as umbrella legislation. The IBC, as we very fondly call it, it introduced a modern insolvency framework, now aimed at expeditious resolution of distressed assets, promoting entrepreneurship, protecting the creditor's interest, time-bound resolution process, creditor-driven insolvency proceedings, and also establishment of certain institutions, including the specialized adjudicatory bodies, and also information utility. That is also one of the important points which we need to really, really consider. Well, friends, there may be a slight overlap with the previous speaker because as he was mentioning that in the cross-border, the RP and the liquidator of Netherlands, they entered into a protocol, but unfortunately, the speakers did not enter into any protocol, and we were given a particular topic. So there may be a slight overlap, which I'll try to avoid because whatever he has covered, I will not like to speak on those issues again. Now, let us also delve into the core of our discussion today, best practices in Indian insolvency and bankruptcy law. Now, friends, what is meant by best practices? The best practices are typically those practices which are instrumental in ensuring efficiency, transparency, and fairness throughout the insolvency processes. Now, I will also highlight some of the key best practices that have contributed to the success of Indian insolvency framework so far. And these are not written anywhere, my dear friends. These are not part of the law. These are not part of the preamble. These are not part of the BLRC. But what is the benefit which we have reaped out of it? And what is the best practice? And I always say that pre-insolvency preparedness, this is one of the best practices which has been established in Indian context. Now, prior to the onset of the financial distress, corporate entities must prioritize pre-insolvency preparedness. Now, this is a lesson which we all are getting, all corporates are getting. Now, what does it include? It includes maintaining accurate financial records, conducting on a periodical basis risk assessments, which is also mandatory part of the board of governance, but implementing the effective corporate governance mechanisms. So now today, in a corporate governance mechanism, when we call it as excellence in corporate governance, it is not only that how you run the company, but how you also keep it outside the insolvency. So this is extremely important that the directors have to be extremely careful while dealing with this subject. Otherwise, the promoters are bound to lose their company. Now, what it does, it encourages early identification of financial distress and promoting proactive measures to address the underlying issues. And it also emphasizes the importance of a robust corporate governance and risk management practices to mitigate the risk of insolvency. This is the bottom line, friends. And by identifying the early warning signs of distress, companies can definitely proactively address underlying issues and explore restructuring alternatives, and therefore they will be able to mitigate the need for formal insolvency proceedings. Well, if there is no option left, naturally the company will go into insolvency, but the first attempt should be made is to avoid those insolvency proceedings. Because whatever you may say, whatever we also may say, whatever the government may say, that we are trying to do the insolvency with the maximization of value, there is always an erosion of value the moment the company comes into insolvency or bankruptcy. So friends, the erosion of the value has to be avoided by the preparedness. So this is one of the best practices which has come in, because now the promoters with this law have realized in an indirect manner that if they are not going to tighten their belts, they are going to be in trouble. So this is one of the important aspects which must be looked into it. And in fact, in the earlier regime of the Companies Act, because I have been the standing counsel to the official liquidator in Delhi High Court for almost 6 years and handled very large scale matters. The problem was in the Companies Act that any creditor to whom a debt of not more than not less than 500 rupees, the amount was very low, 500 rupees is owed. Now that, and if the company neglects to pay for a continuous period of 3 weeks, a winding up petition, which is typically equivalent to a liquidation application, could be filed by such creditor. Now, putting a company just because there is inability to pay debts, because what was the creditor supposed to demonstrate? Inability to pay debts. Now that concept, my dear friends, has changed, has moved from inability to pay debts to default. And default, according to me, is much bigger than inability. Now it includes ability to pay debt, but no intention to pay. So therefore, it is extremely important that now the Indian promoters, Indian companies have to be fully prepared. Otherwise, they will be facing music under insolvency. Of course, even under insolvency, the protection may be given if they are eligible to file a resolution plan. But the second aspect, which is also related to it, which is outside the law, according to me, it is timely initiation of insolvency proceedings. Now, one of the fundamental principles of the IBC is timely resolution, isn't it? But here, what lessons we are learning is that in case the company is facing a financial distress, it should not wait. It should go immediately, because the Indian insolvency law also permits the corporate debtors, the companies itself, and they can also approach the adjudicating authorities, and they can also start the process of insolvency. So financial creditors and operational creditors alike, they must also promptly file applications with the National Company Law Tribunal, which is an authority handling all these matters upon default and for triggering the corporate insolvency resolution process. Now, timely initiation, what it will do, it will ensure that valuable time is not lost in addressing the financial distress, maximizing the likelihood of a successful resolution. Now, that's also very important. So I think there is a need to stress on the significance of prompt initiation of insolvency proceedings upon default, ensuring timely resolution and also preservation of the asset value. And the role of creditor is also very important because it now empowers the stakeholders to take proactive measures in addressing the financial distress. The third most important aspect of the best practices is the appointment of the qualified insolvency professionals. I think India has been at the forefront, my dear friends. The role of insolvency professionals who are appointed as interim resolution professionals, liquidators, bankruptcy trustees, administrators, well, it is paramount in overseeing the entire processes, whether it is insolvency process or the liquidation process. The important point which I would like to emphasize is that the professionals must possess the requisite qualifications. Naturally, they will have to do that. they will have to be experienced persons, because if a company of the magnitude of, say, 60,000 crore of rupees comes into insolvency, do you think you see a person who with an experience of 2 years, 3 years, or 4 years can do that? The answer is no. So therefore, requisite experience is also required. And lastly, the most important the most important point is that a professional must have integrity now to effectively manage the insolvent entities, because the person concerned, the insolvency professional who is taking over the company, who is managing the affairs of the company during the insolvency professional, my dear friends, now he is holding that company or running that company in trust. Now, while being in trust, it incumbents upon him that he must do it you see, with some standards of professionalism, with complete independence, and also transparency throughout the insolvency process. What it will do, it will actually foster the creditor confidence and trust. And actually, this is exactly what we are proud of. The Insolvency and Bankruptcy Board of India, which is the regulator. In fact, I always call IBBI as a super regulator, because underneath the super regulator, we have insolvency professional agencies who are also acting as a regulator. And IPAs are also the service providers. So they play a dual role. But IBBI as a super regulator, I think they have made extreme efforts to ensure the performance of the IPs, the regulated performance of the IPs. And this is one of the important areas which the earlier speaker also highlighted, that India is one of the first to have such kind of a regulator. Well, they have introduced a code of conduct. They are monitoring the performance of the insolvency professionals. If we look at the orders which have been passed by the disciplinary committee, I think there are many cases where they have terminated or suspended many of the IPs also, just because of the non-performance, or there were some issues which were being conducted. So the point what I'm trying to say is that the confidence of the stakeholders actually comes because of these regulations also. So if the regulator is proactive, naturally it brings back that confidence. So the qualifications, the examination, and also regulating them, I think both whether IBBI or whether IPAs, I think they are at forefront of taking steps to ensure integrity, independence, and professionalism, which I mentioned. Friends, the next best practice in Indian insolvency relates to the creditor engagement and formation of the committee of creditors. Well, there can be certain discussion, there can be certain arguments, there can be certain disputes about how to constitute a committee of creditors, whether operational creditors should be a part of it or only financial creditors. Of course, that issue has been sorted out by the Honorable Supreme Court. But even in that judgment, there was an option which was left, that today the operational creditors do not seem to be mature enough and do not seem to have infrastructure. But in future, well, this provision can also be introduced, or they can also be inducted into the creditors committee. But apart from that, we are not on the constitution of the COC, but we are on the subject of engagement. Well, prior to IBC, there was actually, what is written in BLRC is asymmetry of information. Not only asymmetry, the creditor engagement was also to the minimal. So effective credit engagement and of course the constitution of the COC are extremely crucial for a successful insolvency resolution. The COC, which in India typically consists of financial creditors, but they should be unrelated financial creditors. Now it plays a pivotal role in approving the resolution plans and approving and overseeing the conduct of the RP. There are certain provisions where the RP cannot take decisions without their prior permission. And if it does so, such decisions become void, and even disciplinary action can also be taken by IBBI, by the regulator. So transparency, open communication, consensus building amongst the creditors are essential. Well, we faced slight difficulty in the beginning on the role of the COC. There were certain delays, but now the bankers and the financial creditors have realized the importance of making faster decision making. And also it is essential for fostering a conducive environment for resolution discussions and decision making. So this is one of the first things that have brought most of the financial creditors together. and so that the effective creditor engagement can take place. Now, friends, the next best practice which I would point out in the Indian insolvency law is transparent resolution process. Now, transparency, as all of us know, it is at the cornerstone of the insolvency process. It must ensure fairness and accountability to all stakeholders. Insolvency proceedings must be conducted in a transparent manner with timely dissemination of information to creditors and other stakeholders. Indian law, my dear friends, ensures this. This includes typically access to the relevant documents, financial statements, progress reports, enabling stakeholders to take informed decisions and participate meaningfully in the resolution process. Friends, I would also like to draw attention to one of the very important judgments of the Apex Court of India, where one of the promoters, and typically that was happening in a committee of creditors, whenever the suspended directors were attending the COC, they did not have the voting right. They do not have the voting right. But whenever the resolution plan was being discussed, they were being asked to sit out. Well, Supreme Court came down very heavily on this particular process. They said, look, the ex-promoters or the suspended directors are the best people, and being participant, all documents must be shared because in any case, you are getting a confidentiality undertaking signed by them. So even now, the suspended directors' help and discussions will also help in assessing the resolution plans. So this is one of the finest judgments which have been there. The next important best practice is timelines. Well, IBC emphasizes, rather I would say emphasizes, whether it is happened or not, that's a separate issue. IBC emphasizes time-bound resolutions with strict adherence to prescribed timelines at every stage of the insolvency professions. Well, delays will not only prolong the financial distress, but will also erode the stakeholder value and also undermine the confidence in the insolvency framework. Well, friends, there have been certain delays, but progressively, the regulator, the government, the adjudicating authorities are taking steps. They are taking steps proactively to reduce those kind of delays. So all stakeholders, including the adjudicating authorities, insolvency professionals, creditors, and regulators also, they have to diligently adhere to the statutory timelines to expedite the resolution efforts. Now, friends, the next best practice, according to me, is focus on value maximization. Insolvency resolution should prioritize maximization of value for all stakeholders, including creditors and shareholders and employees. Now, resolution plans, they have to be crafted with a view. This is also very important, friends. The resolution plans have to be made or crafted with a view to preserve the going concern status of the entity wherever it is possible or wherever it is feasible. Now, thereby, what will happen? Now, it will safeguard jobs and it will preserve the enterprise value. So value maximization is also very important. It is actually has become the guide for a decision making throughout the entire resolution process. In fact, in many judgments, the Honorable Supreme Court is also relying upon the timely resolution. So the time-bound manner was the word which has been used in the preamble. And typically, it also ensures that there are equitable outcomes for all the stakeholders who are involved. Friends, one of the important aspects as the best practices in India is, and you see, Mr. Batra, the previous speaker also talked about the changes in the law. And he also mentioned that we are going to shift from reactive to a very well thought of. Well, according to me, the Indian government has been very proactive for making changes, because once a new law is introduced, naturally certain deficiencies will crop up, and many things cannot be anticipated. The legislature or the parliament cannot anticipate or envisage each and every situation what is going to happen. So what we need is that proactive amendments which are brought in the law. And I think those changes which have been brought into law are extremely important. Well, just to name a few, immediately the first, the amendment which came, and all of the amendments, I think I don't know whether to call it as reactive or not, but at the end of the day, they solved the problem. All amendments have initially come through an ordinance, and later on, of course, the parliament has passed that law. The eligibility criteria, what should be there for the promoters, the protection of the micro, small, and medium enterprises, introduction of pre-packaged insolvency resolution processes. They have all been, the government has been very, very proactive. And I must share with you one of the examples, that the CIRP regulations, because typically regulations are drafted by the regulator. Now, those regulations, when they came, do you know how many regulations were there? There were 40 regulations. Do you know how many regulations we have today? 75, with the amendments in the law. So, and they have been amended almost 28 times. So 28 notifications have done it. So what all I'm trying to emphasize is that the government has been very, very proactive, including the regulator. The next best practice, which I want to emphasize, my dear friends, is the positive role of the judiciary. Now, if the judiciary does not support a new law, then it is bound to fail. But in India, right from NCLTs or the appellate tribunals, the high courts and the Supreme Court have played an extremely crucial role in bringing clarity to the interpretation of laws by providing authoritative guidance on the application as well as on the understanding of the legal principles. Well, as we all know, landmark judgments, what it does, precedent setting, binding and persuasive authorities, or maybe persuasive, right? It can be anyone. And it also provides consistency and predictability in legal outcomes. And that has happened, my dear friends. Analysis of a legislative intent. What is the rationale behind the statutory provisions? And these judgments have actually shed light on their intended meaning. So they have not just upheld, but they have upheld with giving a reasoning why they are upholding it. There are clarification of many ambiguous terms have been defined. What do you mean by existence of dispute? Well, you see, whether the particular provision or has to be read as and or not. It has happened 2-3 times. Whether limitation is to be counted from which date. The financial statements, whether they are considered as acknowledgement of debt or not. My dear friends, there have been number of judgments by the Honorable Supreme Court clarifying the ambiguity you see in the law. And the legal disputes resolution is also very, very important. The courts have actually provided clarity on the rights, duties, obligations of various parties which are involved, you see, in the processes, role of committee of creditors. There is a recent judgment by Delhi High Court which says that the regulator must also frame the code of conduct for the committee of creditors. What is the role of adjudicating authority? How far they can approve or disapprove? What is the role of an RP? In most of the judgments, we find whenever a particular subject comes, the Supreme Court of India has clarified the RP must do this, and should not do this. So do's and don'ts are also mentioned. So whether suspended directors have a full right to be present in the COC or not. So all these aspects have been resolved. Then, of course, we have the adaptation to the changing circumstances and also the legal certainty which has been promoted. So through reasoned analysis and application of the legal principle, courts have contributed to a clearer understanding and application of the law. And this has typically ensured justice and fairness, my dear friends. This is very, very important because every stakeholder wants clarity. And not only that, there are many companies who are now investing in India. India is a hub. So if they are coming and forming, you see, incorporating companies in India, they need to have clarity. They insist on certainty. Now, the Indian courts, Indian judiciary has provided that kind of a justice in a very shorter period of time and also fairness. So therefore, there is nothing to worry about. And insofar as the international investors are concerned, they can come to India in absolute confidence that yes, their rights will be protected, and whatever justice needs to be done, that will be done. Now, friends, I must talk about not only about the past, but what is future. Looking ahead. Now, as we look ahead, my dear friends, it is extremely imperative to recognize that the journey towards the robust insolvency regime is an ongoing process. Now, while India has definitely made significant strides in strengthening its insolvency framework, but continuous refinement and evolution is essential to address the emerging challenges and also to foster the sustainable economic growth. Collaboration and knowledge sharing. These seminars or the programs like this, these are extremely important. Collaborations and knowledge sharing among the jurisdiction is a key in driving the global insolvency reforms, and it will also promote cross-border cooperation. One must understand the country's law to really foster this kind of a behavior. Well, in Indian context, we are also talking about why should the company go into straight away into insolvency? Can there be a process of mediation that can be established? I think there is a talk here, there is a discussion which is going on, and we can see in a very short period of time the mediation, you see, the practices which may be coming prior to, you see, taking the company into CIRP process. Well, cross-border insolvency, I think the previous speaker has already covered, so I'll just skip that. The other aspect is personal insolvency on a full scale. Well, today, we have started the personal insolvency in stages. The law was amended to bifurcate the individuals into two parts, those who are personal guarantors to the corporate debtor and those who are not. So right now, currently, the provisions relating to personal insolvency of the personal guarantors to corporate debtors has been commenced. But as far as the other individuals are concerned, it has not been commenced. And I think our law, Indian law, is a very forward-looking, be it a government, judiciary, or regulatory authorities. And friends, one more aspect I would like to touch before I conclude is that Indian law and bankruptcy law, it actually exemplifies a very progressive approach. It is a forward-thinking approach. And wherever you make a suggestion, in fact, one example I should give, that before making any regulations or amendments in any regulation, the regulator actually circulates a discussion paper, holds roundtable conferences through IPAs, and which are debated and discussed amongst the professionals, academicians, corporate world, chambers of commerce, and all people are involved. And then based on their suggestions and recommendations, then you see these regulations are framed or amended. So this actually forward-thinking approach typically helps in resolving the financial distress, and it also revitalizes the distress assets. So friends, by embracing the best practices, now stakeholders in India have unlocked the opportunity for economic revitalization. They have promoted investor confidence and also contributed towards a sustainable growth. Look at India, where do we stand today? From a regime of where there was a greater uncertainty, and today we are in the regime of huge certainty. And as we continue our collective efforts to navigate through the complexities of insolvency, well, let us also resolve to remain steadfast in our commitment of promoting fairness, transparency, efficiency in insolvency proceedings. Thank you, friends, for your attention. I now look forward to our discussions and insights on this very, very important topic. So over to you, Shruti.
Thank you so much, sir, for sharing great insights with us and sharing about the best practices in Indian insolvency. Our participants have shared few questions based on deliberation and discussion. So one by one, I'll start with the question. So the first question is, in a recent high-profile insolvency case in India, what were the key challenges faced by the resolution professional and how were they addressed?
Okay, so you want me to answer, or it is directed to Mr. Batra if he's available?
So this one is specifically directed to you.
Achha, okay.
It's for Indian insolvency.
Can you repeat the question, please? Yeah. Yeah, can you repeat the question, please?
Sure. So about recent high-profile. Yes, sir. Yes, sir. Am I audible?
There was some break in your voice.
Sir, am I
because
audible?
earlier yeah,
Yeah.
it is better now. Yeah.
Oh, okay. Okay.
Shruti, you can be
So,
on the video mute.
in a recent
So
high-profile insolvency,
there's some disturbance at your end. Yeah, please go
is
on.
my voice better now?
Yes.
In a recent high-profile insolvency case in India, what were the key challenges faced by the resolution professional and how were they addressed?
Okay. See, once any resolution process starts, there are a number of challenges. The first challenge which any resolution professional faces, whether it is a high profile case or other case, of course, in a high profile case, the stakes are typically high. And the initial task of the insolvency professional who is appointed is to run the company, manage the company as a going concern. And what is the problem which he faces? The shortage of money. That is one of the problems because money is the fuel. So how will he get the money? So therefore, he has to typically make efforts, A, to gather information about the company, to B, to start or restart or continue the process of a going concern of the company, to arrange funds for the company. That is also one of the difficult tasks which are there. To say that how and typically speaking, what happens is when a company comes into this insolvency, most of the employees also have already either have left the job or they are in the process of leaving it. So cooperation is at its minimum. Even the promoters also sometimes do not share that kind of an information. So lack of information is also one of the problems. And then lack of knowledge. See, the resolution professional has to take over. How will he take over unless he has the information where the factories are located, what are the addresses? So all these, having said that, there are provisions in the law which talks about that, yes, the cooperation can also be directed by the adjudicating authority that you must cooperate. And for as far as the financing is concerned, we have provisions talking about interim finance, which actually becomes a senior debt. That means it will be paid as a CIRP cost. So there is nothing to worry about to the people who are lending money. So all these problems and many other problems which we have seen, I think they have been sorted out by a regulatory process and by also by the adjudicating process or the court processes.
Thank you so much, sir. There's one more question with respect to Indian insolvency. In the process of entire CIRP or liquidation, the resolution is two options available for resolution. IRP, RP just publish newspaper advertisement and publish on IBBI website, which is not sufficient mode to identify prospective investors or resolution applications. I think IBBI should onboard more options such as companybecho.com, 99acres.com, etc. for better resolution plans. Kindly please share your views on this.
I think you see these suggestions are there, but it is not that the regulator or the government is not aware of this fact. But one has to really understand that the process has to be absolutely transparent. And ensuring the transparency, naturally, when it is advertised on a website or it is published in the newspaper, it goes through. And let me tell you, whether it is published in one newspaper or two newspaper, that's not the question. It is circulated through our all WhatsApp groups, and the RPs and IPs are making extra efforts. Even I have seen many of them writing to the promoters directly. Like if a large company is there, there is one IP whom I know, he has even written to Mr. Ambani. He has written even to Mr. Advani. So, Mr. Adani. So, all these efforts is not that the RPs are not making efforts. RPs are definitely making efforts, but there is always a scope for improvement. I'm not sure about 99 acres or company Becho. I can't comment on that. But definitely, improvements are always welcome.
Thank you so much, sir, for sharing your views. So, my next question is with respect to international insolvency. What role do alternative dispute resolution mechanism, such as arbitration or mediation, play in resolving international insolvency disputes effectively? So, Sumant sir is available, so please.
Well, Mr. Makhija did comment on that. He did say that this is something which is a growing trend and is under active consideration at the policy level in India. but I'll add two comments, a bit more specific. One, from an international perspective now, this is no longer a trend. It is like an established practice in US, UK, Australia, Singapore, European Union. This is widely used, and mediation, in particular in insolvency, more than arbitration, has come to be recognized as an alternate dispute resolution mechanism. In India, the Indian Prime Minister's office had commissioned a paper on this, which I had the honor of writing. This was presented at a colloquium, national colloquium. Based that, an expert committee was set up by IBPI. And that expert committee has recently submitted this report to the Ministry of Corporate Affairs, recommending mediation, the use of mediation in insolvency. They have suggested that it should be done in phases. And of course, one can go and see the report. It is available on the IBPI website as something which will give you a deeper insight. Also, I want to tell you that that Mediation Act was notified, got the assent of the President of India in November. Mediation Act applies to disputes all across sectors except those that are excluded from the purview of the Mediation Act, and some laws have been. But unfortunately, Insolvency and Bankruptcy Code has so far not been excluded from the applicability of the Mediation Act, which means that as of now, it is the Mediation Act principles which will apply, which means that mediation has to be voluntary. Number two, the timelines are those that are provided in mediation. But the expert committee has recommended to the government that that the Insolvency and Bankruptcy Code should be excluded from the applicability of the Mediation Act, and the entire framework of mediation should be provided in the IBC itself, because the timelines in IBC are much shorter than in other litigations. And in fact, the timelines that are given for mediation in the Mediation Act are actually much more than what the total time frame which is provided in the IBC for insolvency resolution. And that report is with the government. Recently, an international roundtable was held on mediation in Goa, in which Insol International, Insol India, the Insolvency Law Academy, and the Goa Bar Council, University of the Bar Council of India, they passed a resolution also saying that the mediation should be part of the IBC rather than the Mediation Act as far as insolvency is concerned. We are hoping that by the end of the year, we will see some positive movement on that front as well. So I hope that answers the question.
Yes, sir. Thank you so much. So there's another question for international insolvency. How one can collaborate and grow international practices in insolvency? What are the criteria and eligibility?
Well, I'm not too sure if I am able to understand the question completely. Collaboration could be at institutional level, could be at country level, could be at individual level. As far as SAFA is concerned, I think that could become a platform for collaboration in the SAFA countries on international best practices. There are also scopes for other institutions that exist in these countries or even outside of those who can collaborate. If I may say, in the private sector space or institutions that are operating multilaterally on this, Insol International, International Insolvency Institute. In India, there is Insol India, then there's also Insolvency Law Academy. And of course, in other countries also, there are similar institutions, but at global level is primarily Insol International and International Insolvency Institute, which are responsible for global setting together with World Bank, to some extent IMF, who are leading these initiatives. Of course, the UNICEF as well. And those institutions and people who want to participate and collaborate, they can either become members of these institutions where the membership is allowed, or they can collaborate by participating in their project or contributing or giving suggestions, or in any other way as well. And that is how I think the collaborations might be possible.
Thank you so much, sir. There's one more question with respect to international insolvency. Are there specific rules governing the cross-border insolvency in CIRP?
Well, there are not specific rules, but there is a substantive provision in the court which allow or enable India to enter into bilateral agreements with other countries where you could have by way of reciprocity and arrangements to deal with cross-border insolvency. But India has not entered into any such reciprocal arrangement so far. The reason for that is that India prefers the adoption of unsettled model law with some tweaks and as a part of the Insolvency and Bankruptcy Code. Having said that, as I gave the example of Jet Airways, there are also other examples where insolvency practitioners in multiple jurisdictions have cooperated with one another. Also, there is a other framework under the general law, under the Code of Civil Procedure, where cooperation is possible. But that's a long drawn procedure, and that is why the government wants to adopt the unsettled model law as such.
Thank you so much, sir. So my next question is with respect to Indian insolvency. How do you foresee the future of insolvency and restructuring frameworks in India, considering the evolving economic and regulatory landscape? Ashish, sir, if you can please take up this question.
Yeah, see, the future of IBC or the particular insolvency law is extremely bright. Now, what it changed? It changed the habits. It changed the comfort levels of the corporates. A small creditor who was to take money from a, say, large corporate debtor or large company, now he was afraid. And typically the answer was, we are not going to pay, do whatever you want to do. So financial discipline has come in. So financial discipline, once it comes in, well, it will ensure that there is a lesser NPA, there is a better compliances of regulatory provisions. The money which is owed to the creditors, it comes into the market or it comes into their hands so that they can also circulate. So once that happens, the industry will also grow. The economy will definitely grow. So I see the future of, and in any case, those companies which have been restructured and coming back to the fold, ensuring that employment is not compromised, the government is also not affected because they are collecting taxes and other things are there. So typically speaking, this model has been very, very successful, but we have to see the full potential of this particular law in many more years to come. And it is an evolving subject. And I'm saying it is too short a period, see 7 or 8 years, because we have to reduce the COVID period from it. 7, 8, 9 years is still a lesser time to say whether what is the future. But I see the future very bright. Okay.
Yeah, I think we are bang on time, sir. It's 4 o'clock. Questions are also complete.
Right.
So, I'm also very happy to inform the panel that we have been joined by 15 members from 15 countries, including India.
That's fantastic. I think that's really appreciable.
Yeah, so this is the first initiative of this board, which has been taken jointly to organize this event jointly with Triple IP of ICI.
Sarika ji, it is 15 or 1500?
Country, I'm telling.
15 countries. Okay.
Countries are 15 and participants may be more than 1500.
Yeah. So
And-
actually, number becomes irrelevant when we talk about the country as a whole.
And I think I also must appreciate that I am sharing probably dais with Mr. Sumant Batra for the second time, and that also through the aegis of Institute of Chartered Accountants only. Once we did
Yes.
in Mumbai and now we are doing it online. So I must appreciate it is my privilege and honor.
Sir, my privilege also, I started in 2016, everything. And then after 7 years, when people are asking the success of implementation of IBC, I'm again working on IBC.
True.
So, yes,
You,
sir.
you are the pillar.
Thank you so much, sir.
Your video, your mic is muted. We're not able to hear you, Mr. Batra.
Sorry, what I meant, I was complimenting Sarika
Yeah.
for organizing this. And also, I think, Sarika, you should do more of these.
Yes, sir. Sir, Mr. Ibrahim Shabin is here. He is chairman of Committee on Insolvency of SAFA Board. So we will organize more such events with Triple IPI and SAFA Board to take forward and engage with SAFA countries for not only IBC but for valuation also, because this is a consolidated board and we'll work together.
Look
I
forward.
think Mr. Shavim is there. We can request him for any concluding, any closing remarks.
Has
Yeah.
mentioned, yes, this would be the first of many webinars, hopefully, where we believe information, sharing of information is critical for the development of the professional, as well as insolvency or any other profession. So it was a very knowledgeable session. So hoping to have more similar sessions in the future.
Thank you so much, sir. Thank you, Suman Batra, sir, Ashish Makija, sir, Rahul Madan, sir.
Thank you.
Sir,
Thank you.
closing remarks from your side, and Shruti Gupta. In absentia, CA Gyanchand Mishra, sir, who's the chairman and took lead for organizing this event. CA Durgesh Kumar Kabra ji, and President and Vice President ICI, who also took time for addressing. Dr. Ashok Haldia, sir, who's the chairperson of Triple IPI, and the participants from all over the world who have joined and participated in this webinar and asked so many questions to take forward. So the questions shows that they have taken some interest in this webinar and they are still live with this. So with this, I thank you. Rahul ji, over to you.
Thank you, Sarika ji. I think you have summarized, and we have also heard Shabim ji and many dignitaries in the past. I was really glued to the screen when our panelists were speaking. I think in depth, so they have touched not only legal or kind of a act or the code related provisions, but also the philosophical or the rationale or the genesis of many best practices and many new initiative or experiments that IBC in India has adopted. And I can only quote one more, which possibly I couldn't notice getting discussed, is that one of its unique experiment was that considering house owners or house allottees in hundreds of real estate stalled cases in India at par with the financial creditor status. That was one of the judicial experiment that was adopted in view of the public interest. So with that, thank you very much, Makija ji and Suman ji. I think fantastic and many new thoughts came in. We will continue these initiatives, joining hands with ICI. Sarika ji, thanks a lot for closing this and initiating
Thank you.
this initiative.
Thank
Thank
you
you
so
very
much.
much.
Thank you.